Hey, Mr. Lee, you're up.
Thank you, Your Honor. May I please the court? My name is Brian Lee. I'm representing John Dinalo as the personal representative of the estate of his wife, Jacqueline Dinalo. This case comes to the court from a denial of a motion for new trial that Dinalo made. We believe there are many improper actions that were taken, not just by defense counsel, but by his expert or the appellee's expert. And there were multiple comments that were made by defense counsel throughout this trial that we believe individually.
Your appeal challenges the circuit judge's ruling on these evidentiary issues, like 5 of them, I think. And the standard of review, of course, in that situation is abuse of discretion, correct?
It is.
Okay. So then we would have to find that in each and every one of these issues that you've raised, or all of them collectively, that no reasonable judge would have ruled the way this judge did. Is that correct?
I think that I would tweak it a little. Yes, I do believe because you can do either one of two. You can either find an individual error, as we're calling it, warranted a new trial, and you can base your opinion based upon that error and say that this error should have, it was an abuse of discretion for the trial court not to award a new trial based upon this error.
But once again, abuse of discretion is,
sure,
we would have to find that no reasonable judge would have ruled the way this judge did on either any one of these 5 or all of these 5 cumulatively. Correct?
Correct. And I think also when you go to looking at a motion for a new trial is when you look at the cumulative aspect too. The trial that this court can say that once you look at all of the errors of the trial, both preserved and unpreserved, the trial court abused its discretion, basically that a reasonable judge would have said that there.
So what in your view is the most egregious ruling that the trial court made that was preserved?
Sure. The most egregious ruling. Well, the trial court in we're talking about preserved in closing arguments, defense counsel talked about Dinalo's damages, or at least the damages that were put forth by the Dinalo's attorney, Mr. Mitnick, as being I'm sorry, go ahead.
Absurd.
Insane.
Right.
He called it. And then he directly pointed to plaintiff's counsel, Mr. Mitnick, and said that counsel had the audacity to ask the jury for that much money. The trial court ultimately denied the objection, and that came afterwards, and the motion for mistrial.
Mr. Lee, and I pulled it up, and didn't the court direct the defense to stay away from this argument? So the court did, ultimately, and reserved rulings. So it's not like the court totally rejected right there. The judge jumped in and said, stay away from this argument.
Sure, and I understand that, Your Honor, but we're also talking about when there are motions for mistrial made, and the court did reserve on that, right? That is still a preserved error. You know, the court, just because a plaintiff's counsel wants the court to reserve, and the court does, that necessarily means that later on the trial court can then look at that and see whether or not that was not just objectionable, but whether those comments should have led to a new trial.
Right. And if I may, Mr. Lee, because I know you've raised, I think, five points. And would you agree that really the court, as a trier of fact, really stands in the best position? They're there, they're listening to everything, they get to see in its totality, even though there may be problematic things. Every case, there's always issues and problems and things that should not have happened. But ultimately, the court makes a determination, given all of this. So taking everything that you've raised, does that rise to the level that it really vitiates, you're having a trial, to grant a new trial, that it totally vitiated, that you were prejudiced, that your clients were prejudiced, or really goes to the heart of that. So in taking each one of them at a time, I know the first one you've raised the issue about the impeachment of Dr. Stone. That was one of the things that you've raised. And I know you've said that immediately, the counsel moved for a mistrial, arguing that this was the same backtrack tactic. And then the proffer was made in that issue. And so, but didn't the court in that case decline to allow questioning on the topic and basically instructed the jurors disregard the question? So if you look at that specific issue, ultimately, didn't the jurors were only exposed to the brief question of Dr. Stone's denial? So although the court did find it was improper, it also did not find that it rose to the level of a new trial. So this is where I'm getting at, that there's a lot of improper things that will happen in the course of a trial.
Right.
But the key for us to review, does it really go into the heart of this to grant and to follow what Judge Moore said, was there total abuse of discretion in denying the motion for new trial?
Sure, and I'll take that comment and then I'll kind of blend it in with the other ones, because I think when certainly the court can look at, and trial court can look at each individual thing and say, okay, I don't think that this alone caused the entire trial to be, caused the fairness of the trial to be against the plaintiff. And then, and so when you look at the trial court's order, that's what the trial court did. The trial court took sort of these individual points and said, I don't think individually they cause it, and then when you looked at cumulatively, actually the trial court said, I'm kind of concerned about, the cumulative effect, but then also found, but I don't think it rose to the cumulative effect. So when you look, when we have these individual errors that occurred during a trial, but I think that when you look at them as sort of a continuum of the trial, they become a theme. From the beginning of the trial, from opening statement, defense counsel, and these are my words in my brief, so I'm gonna say them, denigrated not only the claim, but counsel and Dinalo in this case. It started from the beginning of opening statement when defense counsel called Dinalo's claim a fairy tale. And it then went to Dr. Stone, as you just talked about, Your Honor. Dr. Stone was asked twice in two different questions.
Before we get to Dr. Stone, let's state, because I want to be able to delve into that.
Sure.
The fairy tale argument, was there any objection made at that time?
It wasn't. No, it wasn't objected to. And we've put in our brief that, we have to concede that. It was unpreserved error. We believe that under the case law that talks about those types of statements, that is fundamental error. But even if the court were not to agree that, we're not going to go as far as fundamental error, that still goes into the calculus of when we start looking at all the other things to see whether there was actually harmful error from a cumulative perspective. So when then we go to Dr. Stone, he was asked twice whether there was allegations. That is those are very serious questions to ask, not just to a witness, to the plaintiff's causation witness in a medical malpractice case. And as the court knows, and I think this court has actually said, medical malpractice cases are a battle of the experts. And so defense counsel went directly at Dr. Stone, at least insinuated that there were allegations twice against him. And then when we went sidebar, as the court knows, the judge sent the jury out. So the sequence is, you hear these two questions, they all go to sidebar, the judge sends the jury out, probably for a good amount of time because there was a big proffer by Dr. Stone, and then the judge brings the jury back in and says, by the way, you're going to disregard what you just heard. All right? So, and I've talked about curative instructions and how sometimes they don't work. And when you look specifically at this case, there were many curative instructions this court had to give during this trial. So we take it from there. Then we go to Dr. Marmariano. I think that's how you say his name. I can call him Dr. M for short. But again, a causation case, a medical malpractice case. He is answering a question from a juror talking about differential diagnosis. And he says to a juror after he coughed, or she, I think, oh, and by the way, you don't have to go to the ER to look for, to rule out a pulmonary embolus. Why is that important? From the beginning of the case, plaintiff's counsel and experts are talking about the coughing that Ms. Dinalo had being a symptom that they had to look for, and it was part of a symptom of a pulmonary embolism. So with that doctor, the defense expert, targeting a juror that coughed and said that comment, that absolutely was improper. Now,
in that case, and for that one, the court did instruct the jury to totally disregard that comment. And one thing, Mr. Lee, that I think, you know, being a trial lawyer, the jurors, they really, I mean, that's the beauty about our court system. The jurors really do pay attention, and they usually love their trial judge. Whatever the trial judge say, they will follow, and they will, you know, they will do whatever the trial judge would say. And in this case, I think I'm pulling it up right now, and it sounded like the defense expert was trying to make a joke, you know, to a jury that she doesn't have to go to the emergency room. And then the court immediately said, you need to disregard that comment, you know, and then the court did recognize it was improper, but is it really, does it go to that comment rendered the entire trial unfair? And then I think that's the analysis right now. And I think you're saying that all of these little snippets comes to that, but we have to look at it that the judge was in the best position. And in each one of those so far, the judge immediately jumped in. The judge immediately, you know, acted upon, you know, these improper, you know, statements. And so we have to look at it in its totality, given the abuse of discretion standard, as to whether or not that totally rendered your entire trial unfair. That's our analysis right now.
It is. And I believe that comment in and of itself should have caused a new trial, should have caused a mistrial to be granted. You know,
I read that comment differently. I read that comment basically as a feeble attempt at humor that no one took seriously.
Your Honor, I wasn't there. I don't think anyone was here. Ms. Savona wasn't there, of course.
No, all we can do is read the record and come to our own conclusions, though, because I don't think that was any effort to give testimony or evidence. I think it was an inappropriate but quick response that was intended to be a feeble attempt at humor that no one took seriously. That's the way I read it.
That's one way to read it, Judge. And another way to read it is that an expert who is talking about a differential diagnosis and has just spent his whole testimony saying that Ms. Dinalo coughing shouldn't have led them to do anything different, the defendants to do anything different.
The problem is if it can be read more than one way, and none of us were there. Number one, we have to defer to the judge who was there, and number two, we have to. And one of the basic rules of appellate review is we have to view the record in the light most favorable to the side that is seeking to protect the judgment. So, I mean, I don't know that we can say there's a way to read it in which it's bad for your side and we should reverse on that basis. I'm not sure how we get there.
Well, I think when we are talking about this, we also have to keep in mind, obviously, the cumulative part, which I'm going to talk about a little bit later, but we also have to keep in mind the special case too, is when there's error that a person points out and that is improper. The beneficiary of that error has to prove that, well, it didn't affect the jury verdict at all. And so that's not our burden to do. That's the appellee's burden to do. And that type of comment from an expert in a case where it's a battle of experts is not a throwaway comment, in my opinion. It is something that goes directly to what that case was about, and it's said directly to a juror who's going to be making those decisions. I don't think that that's reading in. I understand the court may read in that, you know, that was a joke, everything, but just because something was a joke doesn't mean it wasn't improper, and it wasn't fundamentally improper either. So kind of as we go through the continuum again, that's not the last thing that happens. We then get to closing arguments, and defense counsel then makes the insane comment that we were talking about. Says that Denali's counsel has the audacity to ask the jury for that amount, and something we haven't talked about yet, says that twice that John Denalo was accusing this Dr. Khayat of killing Jacqueline Denalo.
Okay.
That is a loaded question, Judge. Those are loaded comments, every single one of them. And the court declined to grant mistrials or reserve rulings, issued again more curative instructions for these, and then ultimately denied a motion for
You did not tell me whether or how much rebuttal time you wanted, but you're down to 5 minutes.
I'm sorry.
Proceed as you wish.
How much time do I have left, Your Honor? 5 minutes. I'll take 3 minutes for rebuttal, so okay. I'll kind of finish the thought. And I understand the court's talking about curative instructions. Yes, there were curative instructions that were entered by trial courts. Trial courts need to do that. I understand that. When these errors are happening, curative instructions are what trial courts do. But the case law that I have cited to this court very vividly talks about curative instructions and how when it's instruction after instruction after instruction, they lose their effectiveness. Every single time a judge has to tell a jury not to do that, they lose their effectiveness, and of a more insidious nature, they make it seem like the party that's objecting or doing those things is hiding something from the jury. There were multiple curative instructions this court had to give. And so when this court looks at not just the individual, but when we look cumulatively at this, there is no doubt in my mind that this jury was tainted. The fairness of this trial from the beginning to the end of this trial was not there for the plaintiff. And in that mindset, the trial court absolutely abused its discretion. There certainly has discretion to look at the trial. The trial court was there, but this court does not have to just take the trial court's word for everything. They can look at the errors, they can look at the legal aspects behind it, and they can find that there's an abuse of discretion, which this court has done in many different occasions, and some of which I have cited to in the brief. I'll reserve the rest of my time for rebuttal. Thank you.
You're right at 3 minutes left. So, okay, Ms. Savona.
Good morning. May it please the court. Teresa Savona on behalf of the appellees. This court should affirm the trial court's order denying the estate's motion for new trial because the comments that were discussed in the motion and discussed here today do not rise to the level for a new trial, whether considered individually or cumulatively. Now, Judge Morris and Judge Kuzum really hit on the head, which is what the standard of review is in this case. The standard of review is abuse of discretion, whether a reasonable judge would do something different than the trial judge in this case. And when looking at these errors that are being alleged by the estate, these do not rise to level of an abuse of discretion. Judge Kuzum, you indicated that the trial judge has this best seat in the house. A trial judge gets to witness the evidence, the testimony, the counsel, the comments, the jury. And the trial judge gets to see how all of these individual comments or statements or questions, how they all play into the grander scheme. And I think that can be seen based on the record in this case. The trial judge's order denying the motion for new trial is a 9-page order. The trial judge went through the factual indications for each of the alleged errors. The trial judge went through the legal analysis for each of the alleged errors. And as Judge Kuzum pointed out, there are several that the trial judge indicated these may be improper or these were improper, but they were isolated. They were not repeated. And I think what is very apparent on this case is that these errors were not pervasive. once an issue was addressed, it didn't happen again. Yes, there are cases where things are happening over and over and over again. And appellate courts have said that is a ground for a new trial. Those aren't the facts here. I would like to address a few of the issues that were discussed by my colleague. I'll go kind of in the temporal aspect of the trial, starting with the fairy tale statement and opening statement. One thing that I would like to point out is that this descriptor was used by the estate in its opening statement, describing the loving relationship of the Dinalos. And as Judge Kuzam indicated, this was not objected to when the defense used the phrase, a fairy tale relationship in its opening statement, so it's not preserved. However, this was something that was repeated as something that was originally presented by the estate. Going to the statements of Dr. Stone, these were questions that the defense posed, asking Dr. Stone why he left Wisconsin. And as the trial judge indicated, what the jury heard was two unequivocal denials that Dr. Stone did not leave Wisconsin amid allegations. And in fact, all they heard was the testimony by Dr. Stone that he left because he indicated to the practice that he was leaving. And so his contract was not renewed because he indicated that he was leaving the practice. And I will, as to be candid, and as Judge Kuzam pointed out, the judge found that even though this was inappropriate, this was isolated. And again, this is exactly what the jury heard. They heard two unequivocal denials. They did not see any piece of evidence that was discussed at sidebar. They never heard anything. And in fact, the defense counsel did ask for a sidebar to discuss it with the trial court before presenting anything to the jury that could have been otherwise problematic. Going to the comment by Dr. Marmurenu, and I hope I am pronouncing that as well, correct as well. I think, when looking at the record, and again, as this court has indicated, we have to look at the record and it's just, these words are cold words. It's from the transcript, it's clear it was late in the day and this was just a passing comment that was unprovoked by Dr. Marmurenu. And what's interesting is, even though there's been discussion here today by my colleague about the use of curative instructions, several times the estate asked for those curative instructions at the trial. So, and this was in one of those cases where the estate asked the court to admonish Dr. Marmurenu and have the doctor just answer the questions. The trial court indicated that he would have the jury instruct the jury to disregard the statement and to then also instruct Dr. Marmurenu to just answer the question, to which he did, and the doctor also apologized. I think lastly, I'd like to just touch on briefly that there were several statements that were made in closing argument. These statements went to what the evidence was at trial. And again, the trial judge is in the best position to see how this all played out at trial. And even though some of these, and again, one of these was found to be improper, the trial judge, who has the discretion on these issues, found it was not so pervasive and compounded by numerous other instances of misconduct as to undermine the fairness of the trial. And I think this also goes, and again, I think the theme of my argument here today is that even if there were errors, they were not pervasive and they were isolated. And this goes to exactly what the trial court found and determined in ruling on the motion for new trial. These individual errors by themselves are not grounds for a motion for new trial, and cumulatively are also not grounds for new trial. And unless this court has any questions, I'm going to briefly conclude. As this court has stated in prior case law, the record is merely cold type and capable of fully recounting the manner in which the record words are spoken. This court must credit the trial judge's perceptions as discussed here today by this panel, if for no other reason than his office and his presence at the trial. This speaks to the trial judge's role, which is not to act as a super juror, but rather to determine whether the evidence is manifestly weighted to one side or another. And unless there are any questions, The appellees, for the reasons discussed here today and those set forth in our answer brief, respectfully request this court affirm. Thank you.
Thank you very much, Ms. Savona. Mr. Lee, you're up for your 3-minute rebuttal.
Oh, I won't take that long, Judge. I'll just briefly rebut by looking at the R.J. Reynolds versus Neff case. It's one of the cases that I cited in my brief. That was a case where there was both preserved and unpreserved errors, and there were cumulative. There was curative instructions given by the trial court throughout that trial as well. And when the 4th District reversed that case, and they found, and I'm just quoting from it, when considering the totality of the preserved and unpreserved errors, all the improper arguments are not harmless error. We are not saying that any one statement in and of itself amounts to reversible error. We are merely recognizing in the totality of improper arguments, preserved and unpreserved, that the errors were harmful error requiring a new trial. We believe that to be the case in this case. Were there preserved and unpreserved errors? There were. Is there one particular error that should have caused a new trial? That's for the court to determine. But when we look at the totality of the errors in this case, both preserved and unpreserved, we believe that the totality of it warranted a new trial. And that's what we would ask the court to do, is to reverse the trial court's order and award a new trial to Mr. Donnell. Thank you.
Thank you, Mr. Lee. Thank you both very much. In order to leave our screens, you need to click the button on your Zoom screen that says, of all things, leave.